Is coming from an expert that is outside of the normal system that the old school guy is working out of. It's not the SBI report. It's not your standard, we're going to bring them in. He's in an environment that he doesn't know, he doesn't understand as far as the reporting and things. It's outside of his world. The way it is, they give me the report. Yeah, you can rely upon the SBI reports for giving all that information. So yeah, just take it on. They can have it. They can try to figure out what's exculpatory. I think it's a little hard for a prosecutor to be the one that figures out what's exculpatory.
It's easier for him than it is for the expert.
But it's easier for the defense than it is the prosecutor, because what might be exculpatory to a defense counsel may be ridiculous to a prosecutor. They don't look at their cases that way. Having worked with some people that have been former prosecutors, they don't come into the defense practice that way. They look at the
part of being a good advocate is understanding the other side's case and to be able to see it from the other side. And I think we've got to assume that prosecutors looking at evidence have to have some facility to determine what might be exculpatory, and when they see it, give it up.
And I think one of the things that will come out of this hearing will be clear message that the old days are over as it relates to what the rules are for criminal prosecutors as it relates to rules of professional conduct. Another example, in the state of North Carolina, there didn't used to be a prohibition on sexual relations with clients. A case was brought, it was dismissed at the DHC level because there was no outstanding rule. We now have a rule. Everybody knows what that is. That's kind of the situation that I would submit to you we're dealing with here as it relates to prosecutors.
I thought there was enough sex in this case already.
Sorry.
That's okay.
So that's my position related to what's going on. I want to kind of take it off a little bit to false statements that are there, because the ultimate issue is going to be your issue to determine. You've heard the evidence, you've listened to it. I hear your concerns. I'm attempting to allay those concerns. I don't have a silver bullet.
Yeah, don't take it personally.
Yeah, but I'm not. I'm just saying I don't have a silver bullet. I think I have a reasonable explanation of what you heard was a prosecutor who has a reputation for truthfulness. He has a reputation or a habit as his discovery is open file discovery policy. That came in yesterday afternoon. And so there are a lot of things he should have done related to that report, but he didn't. And then you take that, and they're also saying that the representations that he made in court as a result of that mistake were false, and that they were knowingly false. And so the one mistake now becomes false statements. He's admitted, and has admitted all along, that those would have been false statements. But he didn't know that they were false at the time. And that gets back to the argument, he should have done more. Why was he just looking for all this stuff? Because he wasn't. It can be as simple as that. And so the way I think to look at it is to go back and analyze if they can establish any sort of agreement. And I think that's their burden. They alleged it that way. I don't think they have evidence there to say that you can have sufficient evidence on a clear, cogent, and convincing standard of some sort of agreement or an agreement on limitation in any way by testimony from a witness who at the hearing where he testified contradicted himself and has since stated on that stand that there was no agreement. I think that doesn't rise to that level. And then you go back to all those statements in court. I think if you look back at the context, what Mr. Nifong was saying as it relates to those statements were, they have everything I have. When the report came in, I gave it to them. You know, they have the report, I have the report. That's all there is. And that goes back to the original, you're missing me on that one. If you look at the language that he referred to in relation to, I can't remember whether it's the June 22nd or September 22nd transcript, where the judge got there and says, now, are you representing that they have everything that you have? Yeah, my meeting with Dr. Meehan, we talked about the use of him at trial. We talked about his report. They have the report. I gave them the report. They have everything that I have. That is true if the report outlines the non-Duke DNA. And so the original mistake then becomes a false statement, but I don't think...
Well, you agree that's a false statement without regard to his intent. That is
he's admitted that. He has admitted that in his deposition. There's absolutely no question. That is a false statement. I think Mr. Brocker says it's a knowing false statement, and then you can get into the intentional point. I think it's a false statement. I don't think it's a knowing false statement, and I clearly don't think that it's an intentional statement. And any time he would have made that statement from May 12th up until December 13th, any representation he made to a court or to any other party that they had all of the report outlined the results of everything that was discussed at that meeting was a false statement. But it all goes back to his understanding of what was in the report, how the report was formatted. Yes, he didn't look at it. Yes, he didn't go back and look at it again. But that is what he is telling you is truthful, and I don't really think you have any contradictions in that. And the mere fact that he said it once, said it again, and said it again doesn't make it an intentional act if it's the same mistake each time along. It might be that he had more of a duty because of the notice that was there and should have gone back and looked, but I don't think that makes it an intentional act by not going back to that duty.
Sure.
I really need help getting past, and this blends with what Mr. Nifong would have understood to be exculpatory, because the defendants told him, you know, we're looking for indications of evidence of other male DNA that showed up in the DESI report. They told him that at that hearing. And not 10 or 15 minutes before that, he had represented to the court, they've got everything that I have. And I understand your argument to be that he said that believing that the evidence of the non-Duke lacrosse player DNA was in the DSI report. And then Mr. Kingsbury, 10 or 15 minutes after Mr. Nifong made that statement, says, we're seeking information of any additional DNA that was found on this alleged victim, even though it doesn't match any of these defendants. And at the end he said, if there are additional male DNA present on this victim, I want to make sure that everyone understands that our discovery motion asks for that material as well. And what takes this, what I have trouble leaving this in negligence, and maybe even at the knowing level, is at that point, how does Mr. Nifong not have an obligation affirmative? Because you can mislead, you can commit fraud by being silent when you should speak. How does he not have an obligation to stand up at that point and say, whoa, instead of waiting until December? I mean, how does that not communicate to him that that's exculpatory, that at least the defendants believe it to be so, and that they do not have it?
Well, I believe if you the next line down, if I'm not mistaken, I believe the court says something to the effect that both the SBI lab and the DNA security will provide that information, if I'm not mistaken. And that hearing was talking about the production of the underlying data. And so the way I had read that was that he made that point. It was about the production of the underlying data. The court, who was talking about having those outside labs, the SBI and DNA security submitted, say, I would assume that that's covered in this report. That's the way I read that. And he should have gone back and done something else, but it didn't click. It can be that simple, I think. It just can be. It's just, I mean, Mr. Nifong is his own unique person. I mean, you questioned him quite a bit yesterday about what is exculpatory, what's non-inculpatory, and things like that. I don't know that I understand all those distinctions. His mind is just his mind. That's the way it works, and it just didn't click. I think that is a reasonable explanation of what happened. And then he said when it clicked, and what's interesting about when it clicked on him, he says that's when it clicked on him. And everybody's saying, well, there's nothing in that motion, why you should think that should be a surprise, or that you should think there's some sort of agreement to withhold, allegations that you're you have some sort of agreement to withhold. That's when he said that clicked for me. Yeah, he should have done it. That should have been a good clue there, but it didn't. And he says that it happened December 13th, and then he doesn't get the benefit of the doubt that that's a truthful statement at that point.